Well, welcome to the final panel. I teased Bill Shepard for putting us here, since whether it's planes or lunch or a beautiful day in London, I know we're standing between you and that. But there's certainly things to talk about from the interesting discussion that we had earlier this morning. My name is Michael Fitzgerald. My formal title is United States District Judge for the Central District of California. What that means is that I'm a federal trial judge. I formerly was a white-collar lawyer at my own firm in Los Angeles, Corbin, Fitzgerald and Athey, Corbin and Fitzgerald, and before that I was a federal prosecutor. The panelists are going down the row here. Eileen Decker, who is currently a lecturer in law. She, until quite recently, with the change in administration, was the United States Attorney for the Central District of California, which means that she was the chief federal prosecutor for both criminal and civil and tax cases for 19 million people in Los Angeles County and the other counties surrounding Los Angeles. Next to Eileen is Jonathan Holmes here in London with the Diamond sponsor PwC. He is a partner in the digital and forensic investigations practice. Aaron Lewis is a partner at Covington and Burling. Before that, he was both a federal prosecutor and counselor to United States Attorney Eric Holder. Amanda Pinto here in London. Amanda is a barrister, a QC. She is with the chambers of Andrew Mitchell QC and is renowned for working on the sort of international cases that are reflected in this hypothetical. And Michael Pisano, a partner at Carlton Fields. Michael is a former federal prosecutor as well. He is also a former chair of the criminal justice section of the ABA, which is sponsoring our institute here. So I'm very pleased to have such eminent panelists here this morning. You know, as I was listening to the last panel, at first glance, it was just so difficult for the lawyers who had to make these decisions, you know, murky facts that nonetheless have to be discovered as soon as possible, all these very subtle judgment calls made about what would be disclosed to whom and when. At least on the face of it, our panel, which focuses on prosecutions, it would seem that there's just a lot more clarity, potentially. It's, you know, we're going to assume that things are out there, that disclosures have been made, that the authorities are aware of the situation that was presented in the hypothetical, and therefore certain difficult decisions that were discussed in the last panel, for better or worse, have been made. Moreover, at least in the U.S., theoretically, there's a very clear and precise process. A grand jury returns an indictment. The prosecutors provide their discovery. The case either proceeds to trial or there's a plea bargain. And if a trial of either the corporation or individuals, there's either a guilty verdict or an acquittal, and if a guilty verdict, then there's a sentencing. But as everyone in this room knows, that is a gross simplification of what actually occurs. One of the things is that, again, at least in the U.S., there are opportunities to try to dissuade the prosecutors from bringing charges at all. Moreover, there are regulatory issues. The regulatory agencies, such as the SEC, can bring their own charges, and then there are private civil litigants, either as a key TAM case where one of the original whistleblowers, at least under U.S. law, might be wanting to bring his his or her own action, which the government in a civil exercise might either take over or not. And then, of course, private civil litigants could be looking at bringing a variety of actions either under the securities laws or in shareholder derivative suits, especially if the sale has gone through, or if we change the facts a little bit of the hypothetical and the sale had been consummated at the same time that these things first began to go to light. And not only is there the complication of having the regulatory and the civil cases, but while textbook would say the criminal case will go first and the prosecutors will make their decision, the regulators will make their decision, the private litigants will go forward, it could easily be where the mix is very different, where the civil litigants or the regulators go forward and use their own depositions, and then somebody representing either the company or the individuals would have to use his or her judgment about what to do in that situation. How is that going to play out against the 800-pound gorilla of DOJ being there in the background watching? I noted in our it was mentioned that private civil litigants watch events with a keen eye. Having often been on the other side of that, Kirby Barra, of course, knows what I'm talking about. It's rather that one gets the sense often that it's DOJ which is watching with a keen eye, which does make the stakes of a civil deposition seem that much higher. So with those preliminary thoughts, let me first turn to Amanda and say, based on the hypothetical and what we've discussed, this was something that Louise and Rob were discussing in the last panel. What do you see as some of the risks of prosecution here, either for the corporation or for certain individuals?
Well, I think the main thing to say is that on the basis of what we know from the hypothetical itself, there may be less criminal offences than might originally appear in the UK. And that's because, for example, in relation to whether the UK's export credit finance was obtained under false pretenses, as it were, or it would have to be, for the corporate to be guilty of a criminal offence in relation to the obtaining of that credit, it would have to be dishonest. In other words, it would have to be making false representations, or it would have to be in breach of trust. And that would, both ways, would involve dishonesty. And as all English lawyers who do corporate criminal law know, it's very hard, actually, to secure the corporate's guilt in a state of mind, a dishonest state of mind, with ordinary criminal offences such as of dishonesty. It would have to be somebody on the board of directors that knew, somebody effectively the mind and will of the company, giving liability to the company, that would have had to have not only done the acts but had the mental state. You can't aggregate state of mind and acts between individuals. So that obviously caused Christine lots of worry as general counsel, but I think as a corporate offence that would be hard to pin on the company. So then, sort of going down a bit, the diversion of the funds to the suppliers' owners and may have been distributed onto unnamed third parties. Of course, that might be a corrupt payment. That might be, despite being overseas, a Bribery Act offence, either under Section 1, or which is the active bribery, or in due course, going down a bit further, the facilitation payment. That's what it looks like to me, anyway, of local officials, which under the Bribery Act doesn't have that same protection that it does under the FCPA. So if that was a facilitation payment, then it would be caught by the Bribery Act. And the way that the corporate would be guilty is by the Section 7 offence of failing to prevent bribery. And it doesn't matter, A, that it's out of the country. In fact, it could be bribing a foreign public official, which is an offence in itself. But you would have to prove, the prosecution would have to prove that either the Section 1, so the active bribery offence, had occurred, or the Section 6 bribing a foreign public official had occurred, and that it was either somebody who was in effect working associated with them, and they had insufficient systems in place to prevent bribery. So it's a failing to prevent. It is the potential offence. And then there's also, of course, money laundering. And interestingly, I think wherever there's bribery under the Bribery Act in the UK, there's very, very often money laundering offences that might also attach. And again, there's an extension of liability here. So even if it's an associate or an agent, it could easily be that the corporate is guilty. I have to say, I don't actually, for myself, see Christine having done anything criminal at the moment. But it's never too late to unearth it. I think that's a few pointers.
Jonathan, you had some thoughts on sanctions, so please share those with us.
Yeah, and related to that, thank you very much. Thanks everybody for sticking around. I had a couple of thoughts, actually. I thought from a UK export finance point of view, in the fullness of time and whether or not you've breached your obligations in relation to them comes out. They're a ministerial department, which means that they're going to be audited by the National Audit Office, and we all know that National Audit Office reports go to the controller, who indeed then convenes a Public Accounts Committee hearing. So not from a criminal point of view, but from a getting your company ready for being put out there in a spotlight, I would think you want to consider some of that. The other piece I was going to touch on, and I'm not sure that we saw it in the last session, because I'm just not sure we quite got there, but there was a link around whether or not these were sort of items that are ending up in Iraq. But even before you get there, when you're talking about sort of stealth drone technology that's got dual use, the Export Control Joint Unit sort of comes into effect, and I think that's something, certainly from a UK point of view, that if you're putting out things that could be used for military purposes as well, you're going to need a license, and that license is going to involve you doing, a degree of due diligence. And I just thought one other point that I wanted to touch on, going back to the UK export finance, but I think it all wraps up into the same world. I mean, when they talk about the three things that they care about in the world more than anything else, they talk about, enabling finance in a global environment, attracting the right sort of talent to their organization, and then they talk about responding appropriately when counterparties appear not to have met their obligations in relation to anti-bribery and corruption policies. So certainly one I think they'll take seriously.
In fact, let me read the final point that in the hypothetical, which is a member of Christine's team mentions that Zako is the name of a city and district in Iraqi Kurdistan, less than 5 miles from the Turkish border. Eileen, as U.S. Attorney, certainly had a lot of experience with national security cases before serving as the U.S. Attorney. She was the Deputy Mayor of the City of Los Angeles for law enforcement and counterterrorism. So, Eileen, what are your thoughts about that wrinkle in the hypothetical, and as well looking at it either because of the nexus of the sale, or if we varied the hypothetical a little to have some of these things taking place in U.S. jurisdiction, what are your view of some of the risks of prosecution here?
So let me start with the latter part first. It is important to note, as during the earlier panel, that looking at the facts just as presented initially on the one sheet, there are very little ties or substantial ties to the United States. As far as we can see in that hypothetical, there are no U.S. victims, no U.S. financial institutions involved, no U.S. securities markets involved. The companies involved are not located in the U.S. The fact pattern says the UK and Germany. They recently started building operations in Eastern Europe, Turkey, and surrounding areas. The lending institutions, as you heard, are EU-based and includes the UK Export Guarantee Department. We did learn the cryptocurrency market was used in some way, but we don't know any details about what sort of cryptocurrency. Although based on yesterday afternoon's panel, we know that it was a Ponzi scheme, or at least that's what I got out of yesterday's meeting. As all the panelists are ready to take aim at me, I'm joking. The commercial businesses involved, the supplier is indicated being in Turkey. There's no information that the customers, investors are related to the U.S. In fact, the fact pattern says the customers are Eastern European. There is one tiny hook that says a global customer base is building, so potentially some of those are from the U.S. But as presented, there's no significant ties to the U.S. So first, a prosecutor would look at the jurisdictional issues, obviously, and as the earlier panel indicated, and as Judge Fitzgerald just stated, we need a better hook. So the last panel added the fact about a potential sale to the U.S., or as we talked about, what if these facts happened in the U.S.? So I'll just take a look at it from a couple of different perspectives to share with you what potential charges are out there in the U.S., assuming slightly different facts. And obviously, whenever there are U.S. investors, or the U.S. stock markets, or it's listed on a stock exchange, or financial institutions that are insured by the U.S. government, there is a nexus and a hook to bring charges in the United States. And fundamentally on these facts, prosecutors are going to look very seriously at fraud charges and the whole list of fraud charges that are out there, including mail fraud, wire fraud if the internet or phone lines are used, bank fraud, and securities fraud. And what type of fraud is really looked at will depend on what facilities were used for the commission of the fraud and what harm was inflicted. So here we see under these facts that a government loan company was used, in which case there would be bank fraud in the United States. But whatever fraud is used, the government or the elements that the government has to prove are essentially the same. And it comes down to what false representations or omissions were made. And were those material facts that people relied on or could have relied on. And in this fact pattern, the issues that prosecutors are going to seriously look at was whether there was a material fact omitted or represented. And one member of the audience brought up earlier, well, do we know how much this loan was for, or the amount of money that was loaned or cryptocurrency was used for? And the answer is no, we don't know that. But prosecutors would look very seriously at what the loan was and was it material. The fact cryptocurrencies were used is also going to be a significant fact to prosecutors because of the volatility of those markets and because it was not disclosed. That is an omission from a prosecutor's perspective. And again, as I said, the issue will be whether it was a material omission. The Foreign Corrupt Practices Act will be looked at, as we've heard today throughout the panel. There's hints that potentially bribes were used in foreign countries, and the Foreign Corrupt Practices Act is to prohibit the payment of bribes to foreign officials to assist in obtaining or retaining businesses. And it also provides that corporations have to keep accurate books and records and have a system of internal controls to ensure that the representations being made about the business and its status is accurate to all investors. Significantly, I should add, prosecutors, just to answer one more of Judge Fitzgerald's question, and to pick up on what Jonathan said earlier about potential national security issues with the technology, much like the UK, there are prohibitions in the US about selling certain types of technology, and there is a list of prohibited technologies that in the US you cannot export because they're viewed to contain some sort of military value, or the underlying technology, we don't want it to be copied abroad and for that technology to be taken apart. And that's when the National Security Division of the Department of Justice will get involved. And those types of charges are obviously quite serious, as the government takes the perspective that our true national security is at risk. So much like the UK, those charges would be seriously looked at. But in addition to looking at the specific charges, prosecutors will look at both the individual and the corporation. And as Sally Yates described yesterday, as highlighted in the memo she issued, but it's now also in what's now called the Justice Manual. Those of you from the U.S. previously knew that as the U.S. Attorney's Manual. It highlights the fact that prosecutors must look at individuals and look at the full extent of their individual accountability for the actions that took place. The theory is that that is the only way to really determine how many people in the corporation were involved, how were they involved, and to get the full scope of the misconduct that could be happening in that corporation. They have to look at the corporation as well. And the reason, I think Sally summarized it well yesterday, is in the past, some prosecutors in some parts of the country would only look at the corporation and not the individuals involved. So it is now mandated that prosecutors look at the individual conduct as well as the corporate conduct and look at potential charges for both. And as Judge Fitzgerald mentioned, the SEC could be looking at parallel proceedings too. But whether to charge a corporation, again, you can look at the factors that are called the Philip factors highlighted in the Justice Manual, and the factors that prosecutors do look at every day in determining whether to charge a corporation. Things like the nature and seriousness of the offense, pervasiveness of the wrongdoing, the history the corporation has of similar misconduct, their willingness to cooperate, pre-existing compliance procedures are enormous, the remedial measures the corporation has taken, collateral consequences, the loss, the investors, the adequacy of remedies, and the adequacy of prosecution of individuals. It all comes down in all the DOJ documents to voluntary disclosure, compliance, and remediation. Those are the factors that prosecutors will continually look at. And one more point before I turn it back to you, Judge, is prosecutors will also look at the compliance programs very carefully. And about a year ago, the Department of Justice issued what they call the Evaluation of Corporate Compliance Programs. And it's a very detailed document, about I think it's about 8 pages long, covering 11 different topics. And it gives prosecutors a series of questions they should be asking about any corporate compliance program. And it's an effort to get away from just like a check of the box. Oh, this corporation has a compliance program. Check, they're good on that. That is not true. And you can tell from the hypothetical that we were given here, which shows the deficiencies in this corporate compliance program if in fact they had one. As noted in the prior panel, it was revealed that there was limited documentation involved. They had sparse records. Compliance signed off, but on very limited facts. All of this fact pattern indicates that the compliance program, to the extent they had one, was really not effective. And so the 8 pages that DOJ put together of questions prosecutors should find out about compliance program really goes into depth about, is the corporation really committed to this compliance program? Do they have the resources needed? Do they attend the board meetings? Do board members directly go to them with issues and questions? Are they part of management? Is there high turnover in the compliance department, indicating that they're really not engaged in the overall corporate policy? And that those 8 pages can be very helpful to corporations, particularly when discussing the issues with prosecutors.
Amanda, I think it was implicit in Louise's remarks that making a disclosure in the UK is with an eye towards trying to get favorable treatment, avoid prosecution. Is there either a formal or informal process, though, by other than just going in and talking, where you can sort of try to influence that decision or get a favorable outcome? I mean, is it laid out somewhere? Do you just show up because you know somebody in the SFO and start chatting, or how would let's say you've been retained either by the company or the corporation or by an individual, and for the purpose of trying to influence that decision, what would a barrister do here in the UK to try to do that?
Well, I think the first thing to say is that the list that Eileen just read out really, I don't think, speaking practically, would stop the SFO from prosecuting. If there was a realistic prospect of conviction, that's the test, and it was in the public interest to prosecute, it is very unlikely, in my view, that they would just go, well, thank you so much. You have been great in telling us goodbye. There are obviously more positive results than a contested trial, and there are the potential, anyway, again in theory really, for a DPA for a corporate, but you can't have a DPA for an individual in the United Kingdom. And so those sorts of issues that are highlighted are all actually part of the sentencing guidelines, rather than, I think, the pre-charge considerations that the SFO would bring to bear. So having said that, I think a lot of the first session concentrated on really, I think, perhaps a timing issue about when to report and to whom to report. And it was really rather sort of teased out at the end that the great unsaid is that if you go to the SFO, you can be jolly sure that the DOJ is going to know pretty soon. I think in 24 statements by the DOJ in the last 4 years, they've explicitly thanked the SFO for cooperation, so goodness knows how many other occasions they haven't explicitly thanked them for. But what one can say is that, as was really set out in the first panel, early cooperation, early involvement will play well with the SFO. I think the real question is whether or not you think there is a prospect that there is in fact a criminal offence that's been committed, because if it really is potential, but it could go either way, you might be finding yourself not necessarily doing the best by your corporate if you do go in early. Having said that, if you do go in and you can show that you are in effect doing what the Serious Fraud Office wants you to do, and you are providing access to witnesses and so on at the first opportunity, and you are in effect giving them material, but also doing what you're asked by them, because to some extent, in my experience, they're directing what they want you to do and taking a part in it themselves as they want it to happen. Then you can, of course, in theory, go down the route towards a deferred prosecution agreement. It's very different from the States, and it's worth saying that although we've had that option now for a few years, actually there have only been 4. And the reality is that, and others in the audience may disagree, and I'd be interested to hear, my experience is that it's really the bigger corporates, they're not SMEs, they're not that interested in giving you a DPA actually. It's the ones in a sense that are too big to fail, and I think Rolls-Royce is a brilliant example of that, because it didn't go in at the earliest, it didn't self-report even. It was responding to the SFO, but it was too big to be prosecuted in effect, and that was why, you read the judgment, you can even see the court bending over backwards just to explain how marvellous Rolls-Royce were. But sorry, I've slightly gone off on a tangent, but I think that there are certainly ways by cooperating that you can make a difference, but the options actually in the UK are relatively little and few. And I suppose one way that you might be able to divert things is in some ways to get to some kind of civil recovery position rather than a prosecution. I suppose that is a possibility, though on the facts here I don't really see it as being, it just doesn't fit this scenario.
let's say that there were just real issues about the likelihood of a conviction for the reasons that you suggested earlier, given the standard that exists in the UK for the corporation. Is there an opportunity then to just point that, does somebody at the SFO just go into a black box and decide, yes, we'll prosecute, no, we won't? Or can you walk into his or her office and be heard on the matter or make a written presentation? Is there, even not necessarily on trying to avoid something which looks like it's provable, but even just the basic point of saying, look, take it to trial, you're going to lose, so let's spare everybody the hassle. So how would you go about that in the UK?
I mean, I think there's a really big difference between the US and the UK. And if one takes bribery out of the situation, because of course that's a failing to prevent, it is designed for a corporate. In that offence is designed for a modern corporation, and to attach liability here, I think there's a very, very different feel from the US in particular, and that is because of the way that we attach corporate liability. So historically, before the failing to prevent type offences such as bribery, such as tax, the authorities really were on the back foot. It was really, really hard to successfully prosecute a corporation. And there are many, many instances of it, and in all sorts of different fields. For example, in transport disasters, where things have gone terribly badly wrong, and they've had a big problem, historically, in fixing liability on the corporate. So what that has meant, I think, is that the corporates were in a very strong position in avoiding prosecution. We start very much from an individual and then go to a corporate, historically, whereas in the States it rather feels as if it's the other way around. But you talk about a black box, and I think rather it's a black tunnel. It goes on and on. And speaking as somebody who's been repeatedly instructed by the Serious Fraud Office in prosecutions, there are numerous moments at which evaluation takes place and decisions are made. And, it certainly isn't in any way siloed. It goes really right up to the top, certainly in my experience. And decision-making is always against those two fundamental principles. Is there a realistic prospect of conviction? Is it in the public interest to prosecute? And yes, you can make representations, and yes, people do.
Aaron, if you were representing the corporation and it appeared that there was a serious risk of prosecution, or there had been an overture from DOJ, again, either because of the pending sale or because some of these events had actually happened in the United States, what would your thoughts be in trying to avoid prosecution of Sparkle, and and also, or perhaps as a prosecutor as well, being on the other side, what do you think prosecutors are actually considering when they're trying to decide whether to bring charges or not?
Sure. So Eileen gave some sense of the breadth of factors that prosecutors consider when they're thinking about whether or not to charge a case. All prosecutors in the United States will consider the sufficiency of the evidence, the probable deterrent value of the prosecution, and the likelihood of success at trial. But in this case, I would think very carefully about how to shape DOJ's exercise of discretion. In the United States, that's really where the rubber hits the road. And the way to do that is to engage with DOJ and to emphasize various of what Eileen referred to as the Philip factors, the factors enumerated in a memo by a previous Deputy Attorney General that guide all DOJ prosecutors when considering whether or not to charge a corporation. In this scenario, Eileen, I think, pointed out rightly that there are indications that there may be an ineffective compliance program. And so before I engage DOJ, I would want to understand why. I would want to the best of my ability, kind of get to the root cause of whatever kind of loss of control led to the facts underlying this hypothetical. That root cause analysis will play a significant factor when we kind of get to the point where we're trying to shape DOJ's discretion. The hypothetical doesn't give us a kind of critical fact under the Philip factors, which is whether or not there's a history of prior misconduct. Recidivists are not treated well under DOJ's policies. But assuming that this is an instance of first-time conduct, obviously I would try to emphasize the potential negative collateral consequences to my client. I would have counseled my client on taking strong remedial actions early, and kind of emphasizing those factors by way of arguing to the department that it should either decline the case outright or enter into a deferred prosecution agreement with the corporation. Under DOJ's current corporate enforcement policy, a presumption of declination exists only in the event that there is voluntary disclosure coupled with full cooperation and appropriate and timely remediation. I was struck by Sandra's comments and Rob's on the utility of usable information. And so in that posture, even if I had interviewed witnesses and had the ability to make proffer statements, I would consider making those witnesses available to agents so that agents could develop the evidence themselves. And I would certainly want to collect and highlight for DOJ the most relevant documents that would be kind of useful in building their case against potentially individuals who could be culpable, responsible for the corporation's conduct.
Michael actually has the practice that all of us like to pretend that we have, which is people have been charged with a crime and they're deciding to go to trial. But Michael, to the extent that somebody, let's say somebody, a CFO who had a false disclosure, or any of the other individuals who could conceivably be facing prosecution here, and you wanted to persuade the DOJ or the local U.S. attorney not to go forward with that, how both in light of the hypothetical and then generally, what have you found to be effective in trying to persuade a prosecutor not to bring charges, not to exercise his or her discretion?
Begging and sometimes weeping.
Widows and orphans.
I have to confess that I find myself sitting in the Rob Zink seat, and I'm not sure I'm completely comfortable with that. But you're right and I teased when Aaron and I were talking that he'd be representing the company, looking to flip on and destroy the individuals who I'm being asked to represent, and our joint defense agreement would quickly but inevitably end. And in this hypothetical, there's a few potential clients that could emerge, as I teased at the last session. If the person running compliance turned out to be alleged to have taken bribes and was a U.S. citizen, that would be a person of particular interest to the U.S. authorities. It also may be in this hypothetical that some of the higher-ups, maybe not all the way up the ladder to Christine, had incentives, having learned of the problem, to conceal it because they didn't want to have to deal with the loan breach. And those people might have liability, and they could end up as clients, and then you may have people up the ladder. Depending upon where up the ladder you are and how up the creek you are, the dialogue with the DOJ is difficult on facts like this. A lot will depend upon what the level of evidence that the forensic people have developed is. A lot will depend upon what corporate counsel has decided and what the company is doing, and how egregious the conduct is and how strong the nexus to the U.S. is. There are going to be some issues I might play in terms of the extradition card, because these people are outside the U.S. And whether it's the foreign corrupt practice issue or money laundering issues, whether it's an export violations controls issue, it's going to be a difficult conversation. You go in, you do your best, you might proffer, you might ask for a reverse proffer, probably both things happen. The government may be more than happy on facts that they have to show me what their cards are because they're convinced that will make my clients more likely to want to enter a deal. So there's any number of ways this could play, Judge. But we would play hard to try to get whoever I'm representing out of this, but it might not be easy.
Judge, could I just add in relation to that, what I think is really interesting with our new director of the Serious Fraud Office is the real emphasis on cooperation, which really has not been the English way, actually. It just hasn't really taken off. We've had this ability to have what are called SOCRA agreements for a long time. They're very, very rarely used. And so I think with Lisa Orfowski in the seat, I think we're going to see a change, or a desired, an intention to change anyway, towards perhaps having more cooperating individuals.
And if I could just add, I hate it. And one of the issues that will come up, and it makes the discussion with the DOJ more difficult, is on the one hand, the client may say, I did it, and I can tell you who else did. That becomes an easier conversation. But what do you do with the client who, despite the evidence, says, no, I didn't take bribes, and I don't know anybody else who did. So they're not in a position, at least ostensibly as you start, to cooperate, and yet you're trying to somehow find a middle ground to avoid a disaster that could be fast approaching. It's not easy.
Jonathan, there obviously the prior panel was talking about the investigations that would have to be done, but just either to gain additional information to try to forestall a prosecution, or if that charges were actually filed in order to negotiate the best plea deal possibly, or to try the case. What else can be done in support of a criminal case even after things have gotten beyond that initial decision of disclosure?
Sure. If I can just take a small step back, actually. I took the liberty of speaking to my Turkish colleagues in the break. So I've got good news and bad news. Exactly how to start. The good news is there's a good chance you can get that data out of the country. Financial data more complicated, but communications and the like, you just need to make sure your IT policies are aligned and that sort of thing. The bad news is sending people to Turkey isn't quite as straightforward. As we know, they're not in the EU. A business visa, which will cost you £10, will allow you to have meetings, but doesn't necessarily allow you to take big piles of data and walk out of it in countries. So you're going to want to think about affiliated law firms, because you can't have any non-Turkish registered law firms in Turkey as well when you're doing those initial investigations and data gathering. So sorry, just another wrinkle. Also, Turkish authorities not super well known for anti-bribery and corruption activities, but extremely well known for tax and issues in regard to them being paid tax. So if any of this loan stuff starts to look like you haven't been paying quite as much tax as you may should have been in Turkey, you can very much expect that you're going to be investigated off the back of that. I think just in terms, and one of the things that you said, Aaron, about this sort of admissible evidence and this usable evidence, we certainly, and PwC and other places, do an awful lot of work to make sure that our evidence that is gathered can stand the test of any type of litigation, whether it be criminal, whether it be civil. And there's a lot of work that needs to be done to get that initial data capture right, and not to find yourself corrupting evidence as you go in terms of collecting it. One of the other points that got raised was around when you actually you suspend an individual. Now that's normally quite an interesting moment, because at the time you're suspending them, you're asking for their phone and maybe their tablet, and you're sort of doing it real time because the reset button's really easy to hit, and that sort of thing. So again, how you capture all that sort of data is interesting. I've spent a lot of time on some cases, sort of almost quasi-working with the regulator in order to make sure that when they're asking for data, they realize what it is that they're exactly asking for. There are two ways you can go. You can, at the SFO, you can wait for a Section 2 notice. You can supply precisely what it says, to the nth degree. You then enter quite often you enter a difficult world with some unintended consequences in terms of quite the volume of data that you're providing and other things like that. And you might find that actually, whereas you're trying to get to a swift resolution on this case, and that helps both sides, you've just landed your regulator with 10 billion records that they need to look through. And in this day and age, that kind of volume of data really genuinely exists. So we spend quite a lot of time working from a technical point of view, if that makes sense, to say, well, I know you want everything that says X, but do you realize that by asking for that, quite what you're going to get from us? And actually, I've had a couple of instances where we've had a dialogue in relation to that. And again, that helps from cooperation and sort of bringing things to a swifter resolution.
In the real world, of course, and Michael's already alluded to this, the process of trying to avoid prosecution and the process of beginning plea negotiations aren't separated out. They're pretty much one and the same. But for our purposes here, let's assume that charges have been brought either in the UK or in the US against the corporation, against some individual. Michael, you mentioned reverse proffers. When have you found that the government is willing to make reverse proffers, and what effect have those had on clients? And let's just say, obviously, we heard yesterday that Brazil and China, I'm sure many other places in the world, the whole plea bargaining process is something that's kind of new, or that, it is just so central to all American criminal cases, whether in federal court or in the courts of the various states, whether it's for a misdemeanor or a felony. It's just, the vast number of cases don't go to trial, and virtually all of those cases have some negotiated plea agreement. Perhaps it's oral, perhaps it's on a handshake. In federal court, it's likely to be much more formal than that. Part of that process, when I say a reverse proffer, is that the government sits down, doesn't expect the client to commit to anything yet, but just will reveal the evidence that it has and how the case fits together. And again, it's something might seem kind of strange, but it's definitely something that happens. So, Michael, what are your thoughts on the reverse proffers?
It pains me because I prefer trials and like clients who are foolish enough to roll the dice, and some do because the stakes sometimes are such that there's no good choice but to fight. But as a prosecutor, long ago, we used to call them open file discovery sessions. And what you quickly found out was the more you showed about your case, the more likely it was that case would result in a disposition. Because it's amazing how much of a gap or separation there is from what the client has told the lawyer and what potentially the true facts are, and what the client now understands those true facts are when confronted with them. So DOJ, and now for a long time this practice has evolved around the country, has allowed prosecutors to show their evidence, and often, the client is brought in, typically it is with the client present, sits mute, and that's an interesting discussion to prepare the client for keeping their mouth shut. Not squinting, not pointing, and I could tell you horror stories of trials where the agent tells you, he pointed to the document and he whispered it frantically to his lawyer. It's like, wait a second, you have to be very careful about how these things occur. But it has a salutary effect if the idea is to avoid, and risk avoidance is a necessary part of our practice, horrible consequences to your client. And so I've seen, Judge, often those sessions do result in a disposition with a person who is resisting being completely candid about what their extent of liability was.
Aaron, you've been in private practice, you've been a prosecutor, you've been a line prosecutor, you've been at the highest levels of DOJ. From wearing any of those hats, what are your thoughts then on reverse proffers, and what's your experience of how the government goes into trying to negotiate a plea agreement?
I generally credit DOJ's prosecutors with operating in good faith, perhaps because I was one, and perhaps I know the folks in the front office of the fraud section. Rob and I were in private practice many years ago. I think they drive a hard bargain, and it is helpful in my experience to have the government's view of the case laid out for my client, because sometimes when we do it, our client will exercise a kind of very normal human skepticism. But when it's agents, not your lawyer, sitting across the table, it becomes real in a way that it was not before. And in private practice, kind of having reverse proffers kind of allows me as counsel to go back and say, okay, look, this is what the risk would really look like. And what we need to do is mitigate that risk. We have to minimize it to the greatest extent possible, and think not about zero, but about something. And how can we resolve this so that you can get on with your business and move on to the next phase?
And Eileen, having been the chief prosecutor for Los Angeles, what were your senses on when? Did you have to authorize a reverse proffer, or was that up to the discretion of your line prosecutors? And what were your thoughts on when it was a useful technique for the government to engage in?
Well, I would generally defer to the prosecutors, although they would always tell me when they were doing a reverse proffer. Really, from my perspective, it was more out of a courtesy to me to let me know they were going to show all the government's evidence, potentially even do an opening statement of sorts for defense counsel and the defendant. Because it does happen largely in fraud cases, obviously, more so than any other. But frequently, it would happen under circumstances where defense counsel would come to us and let us know that they thought it would be very helpful. It would be a way to signal to us that there was perhaps a communication issue, or a client was having trouble believing what the evidence was, or perhaps there was an issue with defense counsel without us ever knowing the precise issue. Frequently, defense counsel gave us the signal that it would be helpful. From our perspective, of course, we were usually very pleased to do it because we did feel it would lead us towards a resolution of the case. And particularly in white-collar cases, these major fraud cases take a long time to try. All our lawyers are willing to go to trial, ready to go to trial. I think they're like Michael. They, being in trial is what they really relish. But yet, the big picture is, I represented a district of 20 million people. I had about 20 to 30, maybe at our peak 40 fraud prosecutors. We had a lot of cases. And to resolve a case and avoid a 4, 6, 8-week trial really was beneficial to us. So when asked, I would give the go-ahead, but my prosecutors knew that they were free to do that if it meant in good faith that we were going to try to resolve the case. And usually we had very good relationships with defense counsel, that defense counsel making the ask or signaling to us that that would be helpful to the case, we were all okay with.
Amanda, we learned yesterday that the rest of the world doesn't necessarily follow the American example of plea bargaining being the essence of practicing criminal law. So what's the situation in the UK on plea bargaining?
Well, I think we've moved slightly towards the US system, but we're practically crawling towards it rather than walking or running. The really important thing to say is that at the moment, plea agreements and DPAs are subject to the court's agreement, so the court isn't bound by them, and that basically makes for a risk that you just don't have in the States, as I understand it. So
it depends. It depends. Yeah.
I mean, the court really jealously guards its own independence here, and it's very keen to scrutinise anything that anybody says. And before one gets to sort of plea agreements or plea bargaining, what you can say is that the court, that there can be an agreed state of facts between the prosecution and the defence. The judge can say, well, I'm fascinated that you think this is all right, Ms. Pinto prosecuting, but I'm afraid I take a totally different view. I think it's absolutely incredible that the defendant meant that, and I'm not going to sentence on that basis. So I think that's always in the back of people's minds, that it particularly actually the defence, obviously, that however much you may have managed to persuade your opponent, you may not actually have a court that plays ball. In distinction to that, if you can get the prosecution to agree to a lesser offence and therefore not pursue something which they originally, for example, expected to pursue. So it could have on the indictment a more serious charge and then add or have already there a lesser charge, and they accept a plea of guilty to the lesser charge, and they offer no evidence on the more serious one, then the court has no option but to accept it. It isn't. I've had cases actually in the past. I remember going into a judge's room in a murder case I was being led in, probably last century, in Essex, and my leader saying to the judge, Your Honour, we've agreed that the prosecution are offering no evidence on murder, and we're going to accept a plea to manslaughter. And the judge said, no, you're not. No, this is a murder trial. And my leader said, no, I'm so sorry, you've misunderstood. I'm just informing you. I'm not asking for your blessing. I'm just informing you that is what is about to happen in court. And it was a really sort of stark reminder of the separation of the powers and the jobs of the different aspects of the judicial system. But save for where they offer no evidence, they don't have to accept what the court says, although I think sometimes they do. They do go and have a rethink, but typically I think in the sort of cases that we do, that would be very unlikely.
Well, one of the ways that happens in the United States is that although some conspiracy crimes have the same potential sentence as the underlying substantive crime, the generic conspiracy statute has a limit of 5 years, and often prosecutors will then choose to charge the conspiracy and only the conspiracy, because then the 5 years that's the lid. So it's an effective device if the parties are worried about whether the judge would in fact implement the plea agreement or not. Let me say whether to Aaron, to Amanda, to Michael, on this, in representing individuals, let's say it was one of the individuals in the hypothetical, or in general, for someone in a white-collar situation to actually have to plead guilty is such a difficult decision to make, especially if he or she feels that that he didn't know what he was doing was felonious, or he feels that it was common in the industry, or that. How have you, when you've convinced yourself that it's in your client's interest to plead guilty, how do you go about convincing the client that it's in his or her interest to plead guilty as well?
I'll be victim to start then. In a way, you could look at the kinds of people that we criminal defense practitioners represent in a couple categories. I, for the longest time, tried to tell everyone that I was that one lucky person that only represented innocent people, and that everybody else was guilty, and thus I was jealous if anybody else was taking a case to trial that was an acquittal, because I think it took one away from me. The reality is that there are evil people in this world, and then there are people who are literally in the wrong place at the wrong time. Good people who have bad things happen to them. And for that kind of client, the high-level businessman or woman, never been in trouble before, commander of their business, used to making the decisions, control freaks, the whole process of being involved in a criminal case charged with fraud or other allegations is incredibly devastating. And it has not only a personal effect on them, but on their business and on their family. And all of that sort of comes to roost as defense lawyers, where we sometimes, in private conversations, see ourselves as much psychologists or sociologists as criminal lawyers, because of all the different factors that we have to deal with in trying to advise a client what is in their best interest. Some clients want to hear a judge, some clients don't. I've sometimes said to people who ultimately disagreed with my view of the case and said, let's go to trial. Great, because I tell them, if you really want a plea bargain, there's better lawyers that can really do that than me. If you want to go to trial, hire me. But inevitably, you learn facts, and then the client has to face what those facts are. And I've wished I held them upside down over a wall and shook them until they would agree to take a deal. But you don't get to do that. And so it's a dialogue. The reverse proffer helps. Sometimes some people just can't. Sometimes you find out after a while that a client takes a while to really talk to you about what was going on in their lives. a case long ago, a man who had government contracts who turned out to be involved with false documents had insisted, family business, that he hadn't done anything. And then it came to pass that he had a back problem and was on some opioids, and actually, finally agreed that, it probably did happen the way that the government said it did, and ultimately the case was resolved quite favorably to him. But it's not easy.
I can just add on to that. I mean, sometimes it's a question of kind of guilty of what, right? And so the client will kind of feel very strongly that she definitely did not do this, but perhaps she was not entirely truthful when the FBI interviewed her, and so she could be guilty of that. And so determining kind of what conduct will form the basis of the guilty plea can go a long way in getting your client there. And sometimes it's an odd position. You're kind of, on the one hand, pointing out the weaknesses in the government's case to the government, on the other hand, pointing out the weaknesses in the client's case to the client, trying to kind of get to a kind of optimal resolution for the client based on your perception.
I always thought that the barrister-solicitor system was great, so that the one could be the bad cop and the one could be the good cop, and you didn't have to deal with sort of well, aren't you my lawyer or are you my lawyer? I will say, and it's a concept I hate and fight against, but when you're trying to talk to clients about finding a way to avoid risk, the notions of deliberate ignorance or willful blindness are often things that clients can come around to and finally accept easier than to say that they were willfully involved in a criminal act. So that sometimes is helpful.
Well, that's a good point. Amanda, as the barrister, how involved are you with the client's decision on whether to plead guilty or not?
I'm the bad cop. I think, it's interesting because I think one of the really big problems in the UK with fraud and related offences for clients, for individuals, is this concept that they have to admit that they acted dishonestly. If there was another offence which didn't require that, so in a sense, in a way, money laundering actually is better because it's knowing or suspecting that the proceeds are the proceeds of crime. So in a way, that is a different mental element that you're signing up to, that you suspected that they were the proceeds of crime. Just has a very different feel to the client than going, yes, I acted dishonestly. And I think that really is a massive problem. And in fact, I've literally had this situation that you're talking about where I know, I can't tell you how I know, but I know that my client would have had a really, really good result if he had pleaded guilty. But the client could not and would not accept that he had behaved dishonestly. And so there was simply no possibility of pleading guilty. And the other thing, of course, is that I think there are, it may even have been with Lucy, and I was on a panel many years ago, but doing the unsaid consequences of conviction, which are also issues that you have to bring up with clients. Are they going to be banned from being a director? Are they going to be disqualified? Are they going to be able to go, for example, to the States? Are they going to have other orders made against them limiting their conduct? Are they going to be able to ever get employment again? Those very, very basic and issues which don't have the I word of imprisonment or the F word of fine. Those are real issues for ordinary people, and or even regulatory repercussions. I think those are issues that you obviously have to tell your client what might happen. Interestingly, in a case that I'm in at the moment, there's going to be a retrial. But one of the people, because Europe did not extradite its defendants to the UK, Germany and France didn't think that they had committed criminal offences in relation to Euribor rigging. They didn't recognise that there was an offence, and or it was too old. It was past its limitation. But the interesting thing was that there were other people from those jurisdictions who did turn up and who did face trial. And so these are all risks that you're having to balance. And just very recently, somebody who was not extradited, but for whom there was a European arrest warrant outstanding, rather foolishly took a holiday to Italy. And he is on his way back.
Can I just add to what you're saying? Because you brought up directors' disqualification, all the rest of it, and obviously there's a whole another layer of complexity that comes from being, let's say, a chartered accountant, or even a lawyer. Is that something that the conversation comes around those ways as well?
I mean, absolutely. I think when people are looking at their lives going forward, there's a very different feel, actually, if I may say so, to admitting your guilt and being wrongly convicted. And you can kind of persuade yourself that you've been wrongly convicted. But if you in the UK anyway, if you admit your guilt, it's very difficult to explain to people that you're not guilty.
And by the way, it's funny that issue of collateral consequences often is something that we as defense lawyers will bring to the prosecutors as a reason for lesser charges or no charges. So it sort of flows both ways.
And again, in the United States, the collateral consequence is that as a felon, one is not allowed, at least for a number of years, to own a firearm or ammunition. And for a number of Americans, that's just it. I mean, they will not plead guilty to a felony just for that reason.
Judge, just before we move on, I remember that one of the other consequences is that you weren't allowed to have a dog. There was
Wow, I have not heard that. Wow.
Stuck with me.
All right. We were finally going to discuss sentencing, but I see that we don't have that much time left. So let me open it up for questions. Do you have any questions for our eminent panel here of prosecutors or former prosecutors and defense attorneys?
I have a question for Amanda. Amanda, do you have, as we have, know or should have known jury instruction? Michael said that is very, I think that's very powerful, that jury instruction for the government. Do you have a similar?
Do you mean as an ingredient of the offence?
As an alternative way of someone being convicted?
Right.
In other words, instead of yes, I knew, should you have known?
No. I think there's a general proposition, no. That there is an exception to that, and that is in the regulated money laundering sphere. If you are in the regulated sphere, then the fact that objectively you ought to have known or suspected that it was reasonable for you to have known or suspected that you were dealing in laundered funds, then that is a part of the offence. But there is no lowering of the alternative to the dishonesty ingredient of fraud in the UK.
Judge, I have a question for you, if I could, and to any of the prosecutors who would be willing to state their personal opinions. C1C, please, because in the U.S., and it is in some jurisdictions very rare, many judges will not want to be asked to consider them, but there is a possibility that a prosecutor and a defense lawyer can agree on the actual sentence, and then it is provisionally presented to the trial court, who presumably will order a pre-sentence report and then decide whether the judge is okay with the result that the parties want or cannot accept it. If the judge says no, the defendant could still go to sentencing or is allowed to withdraw his plea. But are you seeing that much, and what do you think about it?
Well, in a sense, I see it all the time because it's part of what we call a fast-track program, where for the crime of returning to the United States after being deported, after being convicted of a felony. So in order to process, there's no way around it, just to process the cases as quickly and equitably as possible. There's they agree to the day of what the sentence would be, and it's done very early in the case, no fuss, no muss, and the expectation is that the court will do it. And I have almost always done so, in part because I do think it's a way to have an equitable disposition of a very large number of cases. So, but otherwise, I have yet to have somebody approach me on that on a real important substantive case.
So I have a story on that. We did have one case, and you'll know quickly what case I'm referring to. And I'm not going to say the defendant's name. It was a very high-profile figure that we were prosecuting. And we did offer the defendant, and the defendant did accept a stipulated sentence that we presented to the court. The court took the guilty plea. Pre-sentence report was issued. And the plea, I think, was to a 6-month term. And given the high-profile nature of this particular defendant and what the government perceived as a very difficult case to try, that's why we offered it. And the court initially accepted it, got the plea, but decided 6 months was not good enough for this particular high-profile defendant. We went to trial. We went to trial twice because the first time it was hung 11-1 for acquittal. And then we retried it and got the conviction. And the judge ultimately sentenced that defendant to a higher sentence. I think, but I can't speak for that particular judicial officer, that he regretted not taking the plea. He didn't know how the case would play out in court and in trial, and it was a very, we always perceived it as a difficult case for a lot of reasons. But there was no way to signal to the judge, there's reasons defense and prosecution came to this agreement. It was outside the typical fast-track case that the judges see a lot. It was a little unusual. And I think our office would think twice now about ever doing it outside that norm again because of that experience.
Any other questions? Yes.
What about the article recently where a personal defendant is, the lawyers are claiming that the company investigation is somehow sort of biased against them. So if I'm the compliance officer, I'll be saying, well, actually, the general counsel was involved in the deal with export credit, and one of their legal team is based in Turkey, and they signed up to the legal. So why are you directing them? And I just wondered from the panel, is that something people expect to see more of, that individual defendants try and found about the company investigation? Or is that not really a theme?
Well, I'll suggest to you that the creative defense lawyers are always looking to add pages to the defense playbook. And the traditional theme was government misconduct. Some lawyers pound that drum, and we can argue whether it's appropriate or not. But to juries who may in fact be bothered by the connection between a company with incentives to create a result and an investigation that might have been steered to make that result happen, it becomes a very valuable aspect of the defense, I think.
Yeah.
How does a company manage that?
I'm not sure that the company's particularly interested in managing it, to be honest. I mean, I think there's more and more of a climate where corporates are being encouraged to offer up individuals, and the repercussions for those individuals are something that sometimes I'm afraid the corporate's perfectly happy to.
Although I will note that it sometimes becomes awkward, since typically, and particularly in the U.S., the company's paying the legal fees for that individual who's going to trial, now blaming the company for being forced to trial. So I'm not sure where that all plays out.
Any other questions? All right, well, thank you very much for sticking around. We appreciate it.
Well, thank you for that excellent panel to finish off our day-and-a-half event here. I wanted to just take a moment and first to address Amanda's point. Collateral consequences are an issue that the ABA Criminal Justice Section has worked a lot on in recent years. The one that she was referring to in particular is one of 2,200 different collateral consequences that apply to those convicted of felonies and misdemeanors in Illinois alone. And it makes it a crime for a convicted criminal to own a dog that is not spayed or neutered. So it just gives you a flavor for how broad these topics have become in the U.S. So let me end simply by thanking again our sponsors for generously supporting our event here in London, to our hosts for letting us use this excellent venue as we have for the past many years. Of course, to our speakers who have given us a lot to think about over the last day and a half, and to all of you for participating in this event and offering some excellent questions and insights as we discussed some of the most pressing issues in the field. I hope that you will join us. We have immediately following this, the Institute reception just outside the doors here, and then I know some of you will be attending the Women in White Collar Crime Luncheon program, which will begin at 1 o'clock. I also hope to see you at many of our other events throughout the rest of the year. Of course, in the spring, we have our National White Collar Crime Institute in New Orleans, followed by the Global White Collar Crime Institute in Prague in June. And then, of course, next year in October, we'll be back here in London for the 8th annual London White Collar Crime Institute. So we hope to see you at those and many other of our events with the criminal justice section. Thank you for being with us.